The next matter before the court this morning is Patricia Welch versus Prompt Recovery Services. Are parties that we are, the council and parties that we're expecting, if any, here and ready to proceed?
Yes, sir.
Okay. Come on up. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, please let me know when you get started, and I'm keeping the clock this morning to keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
May it please the court, my name is Craig Adams. I represent the appellants, Prompt Recovery Service and Glenn Vansek. Briefly, Prompt was a third-party collection agency. Mr. Vansek was the owner and president of Prompt. Ms. Welch was hired as a bookkeeper by Prompt in October of 2008. She took a leave of absence in November of 2011. She started doing some work for Prompt while she was at home. She was ultimately terminated in March of 2012. A dispute arose regarding the payment for any work she had done while she was at home, which resulted in a lawsuit. Trial court awarded Ms. Welch approximately $3,400 in unpaid wages, $6,700 in statutory damages, and approximately $12,000 in attorney's fees. It's the appellant's position that this judgment was against the manifest weight of the evidence, abuse of discretion, and contrary to law, the grounds that it was unreasonable, arbitrary, or unconscionable. I have a couple issues to discuss. First issue is with regard to whether Mr. Vansek was an employer under the statute. The court, in its opinion, made reference to the economic reality test, focusing on two of those factors, the one dealing with supervision and controlling of the work of the employee and the maintenance of the employment records. Generally, the appellants did supervise and control the work and did maintain records, but specifically with regard to any work that was performed by Ms. Welch at her home, the appellants, particularly Mr. Vansek, had no supervision or control of that work, and there was no maintaining of those records on his behalf. That was all on.
What were the general terms of what happened if somebody took a leave of absence? Was there any general policy or any previous method of keeping track of time and so forth?
It was rare because, again, it was a collection agency, so most of the employees were people who did the collecting calls, and then there was some...
But did they work at home like she did?
No, everything was done there.
Right.
This was more of an exception to the rule, because more often than not, these people who did the calling to collect these debts on behalf of their clients did the work there. They didn't go home and make calls. She was in administrative and business, so she was able to do some work through the computer at her home, because she was able to work remotely by tying into the system.
Right. If she had been working from the work site, would there have been a general timesheet?
Yes, she was the bookkeeper and basically dealt with the documenting and charting of the punching in and punching out of the employees, documenting what the hours were for the work that they did.
While she was at home recovering, she did work. Did she use the same timesheet?
No, she had the ability to log in from home.
So she would have filled out that timesheet on the computer, assuming she put down the correct hours, there would be no problem.
In effect, yes. She, again, with regard to, again, the supervision and the maintenance of those records, she was the only one who had access to the drive in the company's computers that did the documenting and charting of hours worked. So with regard to, generally, appellants did supervise and maintain those records, but with regard to anything done off-site, with regard to Ms. Welch, they had no control over anything that was done there. With regard to the type of work she did, the hours that she worked, how those hours were charted or documented in the system, that was all done by her remotely through a computer system that she had access to. So again, with regard to meeting those, satisfying those factors of that test, it's our position that all the factors weren't there, that with regard to the work that was allegedly done at home, they didn't meet, or he didn't meet the test of being an employer under the statute.
I understand that under the statute, what the arguments are related to Mr. Vancic, but is it conceded that Prompt Recovery Services, Inc. is governed by the federal statute that the liability was found under?
As the state statute seems to be bootstrapped to the federal statute, I would agree. So with regard to Mr. Vancic himself personally, it's our position he does not fall under the definition of an employer because of, again, the absence of satisfaction of those two standards. The second issue deals with the inference that the hours that Ms. Welch claimed she worked represented the full amount of the time she had worked. The trial court had stated that under Revised Code Chapter 411, it's Mrs. Welch's burden to prove the number of hours worked, and that she would satisfy this burden if she proved sufficient evidence to show the amount and extent of that work as a matter of reasonable inference. Again, it's our position that she failed to meet this burden. Per the magistrate's decision of May 6th, the magistrate stated that the log maintained by Ms. Welch that account for the hours she worked reflected few dates. It was just arbitrary numbers of hours, or no dates that you would see on, let's say, a typical punch. You know, you punched in at 8, you punched out at 5. It was just a kind of a list that she and only she had access to on this one drive.
So your position is that because she had access by computer to the computer at the office, she could have used the office time log instead of her own version of
Correct. That's how she did it from home. She would go into the drive that she had access to and say, I worked these many hours. But there was no real documentation as far as, well, on this date I did this for this many hours, and then there was a total at the end stating, well, therefore, these are the dates I worked, these were the type of work I did, and these were the hours. It was just 9 hours, 12 hours, whatever they were, and they added up to a total of about 193 hours.
So if she had been working on site, she would have put down the client, or whatever the call, and the full details. Mm-hmm. And what you're saying is, even though she could fill in that form from her home using her computer, she did not give details.
Correct.
She only gave a subtotal of the total number of hours.
And just a listing of 5 hours, 9 hours, whatever hours that ultimately, when you totaled them, came up with what she claimed she worked for that time. And it was,
Well, how different was that from what she would have done had she been at the office? Would she have to log in
she would,
every single transaction?
yes, and it,
Okay.
yes.
Every attempt that she made to collect.
Well, there would be a showing of work that she did, and there was evidence produced at the trial that did show a charting of the, one of the functions she did was to process credit card transactions. So there was a listing of, on this date, you know, this credit card transaction was had. So there was evidence that we provided to the Ms. Welch that showed she did this many transactions over the course of time with regard to that function or job duties. Okay.
So that would be okay to pay for it.
Yes. I guess the argument is that there's an arbitrary listing of hours, and from that, which is not basically documented by anything other than her listing what hours she worked, then to state that even as the manager said, it's impossible to determine from the log the hours worked in each day by Ms. Welch while she worked from home, and that she worked unsupervised. So there was to say, well, these are the number of hours you worked based on a small sample. We don't think was a proper inference to say, this is how many hours we think you worked, and here's some evidence that showed it, and therefore we make that leap to show nothing that's documented leaps to the 193 hours that she apparently worked.
I'm sorry. When she went to go work at home, was there some agreement reached? Was she supposed to be paid transactionally, or was she supposed to be paid hourly like she'd been before, or how was she supposed to be? Was there any agreement as to how?
I think it was my understanding that wasn't sure she had a health matter and that she was allowed to work, and because of the ability to electronically do things that she normally would do at home, she was permitted to carry on those functions.
So there was never any discussion of how pay would change because she's working from home as opposed to working from the office?
No. No. I guess that on this issue, we think the inference is unreasonable. Because again, I think the magistrate said, well, you didn't have this, you didn't have this, you didn't have this, but we're going to make that inference anyway to get to this amount of time she claims she worked, despite the fact there were no dates on, how she got 8 hours, how she got 5 hours, how she got 12 hours. So that's our issue on with regard to that.
And counsel, I don't recall if you reserved any time. I want to let you know you have just over 3.5 minutes remaining. You may proceed to reserve as you want.
Okay. And again, I just have one other issue, and it goes to, again, the sum total of the judgment here. Again, the issue of how it was decided she accumulated those hours, and that translated into so much in unpaid wages, and then the attorney's fees. Again, our argument was, again, we're talking about a big inference here to get to those unpaid wages, and then to add on, maybe 3 times as much in attorney's fees to get to based on a number we're still having a hard time wrapping our minds around. So again, we think the granting of that amount of attorney's fees was an abuse of discretion in this case. With the time remaining, I'd just like to conclude by saying we feel that the judgment of the trial court should be reversed on those grounds.
Good morning. May it please the court. My name is David Truman, and I represent the appellee, Patricia Welch. Before I get into the 3 points that I want to address today, I want to briefly speak to appellant's argument today, which is essentially an effort to retry the case. Appellant did not file a transcript of the trial in this matter. Rule 53 requires, in a case decided by a magistrate, that when you file an objection to the magistrate's decision, you file a trial transcript so that the court can review the facts that were put into evidence and make a determination. Appellate Rule 9 requires, when you file an appeal, you file a transcript of the trial so that the appellate court can make judgments about weight of evidence and can review the facts to determine if there was something improper. In this case, appellants did not file a transcript at the trial court level. They did not file a transcript with this court when they filed their notice of appeal. So the facts in this case are as the trial court determined. Appellant is trying to argue inferences that should be drawn from evidence. Appellant argues that evidence that was submitted at the trial court is insufficient to support the judgment in this case. Those arguments are foreclosed. They're not available to appellant because they did not file a trial transcript. And so I want to make clear to the court that appellee feels it's very important that we not get caught up in arguing about what evidence was presented, what inferences were drawn. Those are irrelevant at this point. This court should review the facts as found by the trial court and only consider questions of law based on those facts as found by the trial court today. Now, the first point that I wanted to address was whether the damages award was proper. The court in this case found 2 violations of Ohio Constitution, Article 2, Section 34A. The first violation was the failure to pay wages as required by Article 2, Section 34A, and the corresponding statute, Revised Code, Section 4111.14. The second violation of both of those articles of law was the failure to maintain accurate payroll records of the appellee's hours worked for each day worked. The Constitution is clear that the employer is tasked with maintaining those records.
Excuse me if I interrupt.
Sure.
If your client was keeping her time records on the computer, how is it that the employer is at fault for not keeping her records?
Thank you, Your Honor. The Constitution places, as well as Revised Code Section 4111.14, places the responsibility on the employer at all times to make sure that payroll records are accurate. The employer has the ability to train its employees. The employer has the ability to discipline its employees. The employer...
Excuse me again. But in this case, the employer is accommodating his employee because of apparently some sort of hand difficulty. She's on leave, and he has no practical way of ensuring the accuracy of the time records. What is it that he should have done under these circumstances?
In this case, first of all, I dispute the fact that, or any suggestion by appellant's counsel, that the employer was simply accommodating the employee. The employee, and this was found in the findings of fact and conclusions of law by the trial court, that both parties benefited by this arrangement, and they agreed to it. But to answer your question, Your Honor, the employer should have required the employee in this case to input the time in the manner that it wanted. If the employee wasn't doing it, the employer could discipline the employee. The employer can fire the employee. The employer cannot decide not to pay the employee.
Doesn't she bring in, even though they were generated by her, but in order for her to prove that she's not been paid for a certain number of hours, she uses employer records for that. She generated them herself, but they were employer records, were they not?
She did use some records for that, yes, Your Honor.
Okay, so there's a finding that the employer is at fault for not maintaining records.
Correct.
Is that just a finding that if there's a dispute, you haven't been able to show? That's different than the finding under the statute that they haven't made records, because after all, every record she makes for herself is an employer record, because it's her job to do that, right?
Your Honor, there was a lot of evidence in this case, which again is not here because we don't have a transcript, and it demonstrates that Ms. Welch worked hours for which she received zero pay. For example, December 1st through 15th of 2011, we, through discovery, obtained records of payment transactions that this collection company received, which were processed by Ms. Welch. This is beyond dispute. The trial court found it in the trial. She received zero pay for that period. Mr. Ivancic, the individual defendant, appellant in this case, signed the paychecks. Mr. Ivancic was the president of the company, the sole owner of the company. He was Ms. Welch's direct supervisor. He knew that she was performing work while she was at home, and he knew, and this came out in the trial, he knew that she did not receive any pay for that period. And the agreement between Ms. Welch and Mr. Ivancic, as well as Prompt, his company, was that Ms. Welch would bank her time so that when she traveled, or when she was unable to...
What does bank time mean?
She was tracking her time on a sheet, and that's, I believe, what the appellant's counsel was referring to. Tracking time that she was not being paid for, per agreement with the employer.
Yeah, but That doesn't help me understand what the term bank time means.
It simply means that she was recording hours that she worked for which she was not paid.
And when she recorded those hours she worked for which she was not paid, was that recording not an employer record?
It would be an employer record, but it still did not comply with the Constitution. And the reason is, the Constitution plainly requires the employer to track the hours worked for each day worked. The record that she made did not comply with that. But again, the Constitution of this state, the law of this state, and frankly, the Fair Labor Standards Act, under federal law, all put the responsibility on the employer to document properly. The employee is not tasked with maintaining their own payroll records. If there is a problem with the maintenance of payroll records, it's the employer's job to train the employee how to do it in compliance with law and how to make a proper record so that the employee can be paid.
Was she doing the same thing at home as she was doing when she was at work?
It was tracked differently because if she placed her time that she was banking into the ordinary system, she would have been paid for it. The point was to delay the payment for future use as compensatory time, which is also not legal. But again, this was the employer's agreement with Ms. Welch.
So if she came in and said, I know that I worked all of these hours, but they didn't keep any record of it, so this is how much I worked, but even though there's no record, they don't have any record of it, you would say, well, there's a failure to maintain records, so they should pay damages.
I would say if you can prove it, and we did prove it.
Different question, right? Because a liability is found under a specific part of a specific statute about maintaining records.
Correct.
Okay.
Correct. If the employer fails to keep records or fails to require its employee to keep records, then they violate the Constitution, Article 2, Section 34A. In this case, there are two violations, though. The failure to pay as well as the failure to keep records.
Different obligation under the statute, different damages flowing there from, theoretically anyway, correct?
Yes, Your Honor.
Was there discussion, I understand there's no transcript, so I'm not asking about things that might have been heard that we don't have a record of and cannot consider. But in the pleadings, was there an acquiescence as to liability under the Federal Fair Labor Standards Act?
No, Your Honor. The FLSA was not pled in this case. This is strictly an Ohio law case. The FLSA comes in because the Ohio Constitution relies on the FLSA for the definition of employer, which is why Mr. Ivancic was personally liable as an employer in this case.
So then if the reliance on the FLSA's definition of employer is incorrect, doesn't hold true with this case, then there's no liability under the Ohio statute?
There would be no liability for Mr. Ivancic. There would still be liability for the company. However, the trial court got it right. The employer, the definition of employer under the Fair Labor Standards Act is extremely broad. And it's likewise extremely broad under Ohio law. The definition is essentially any person who directly or indirectly acts in the interest of the employer with regard to an employee. And that has been interpreted by federal courts as well as Ohio courts by the use of the economic realities test that Mr. Ivancic mentioned. In this case, the trial court found that Mr. Ivancic easily satisfied the test. He had the power to hire and fire Ms. Welch, and in fact, he did both of those things. He had control of her work schedule and work conditions. He was the one who approved her working from home, and in fact, wanted her to work from home while she was recovering from her surgery because it allowed his company to get business done. She was the bookkeeper. He had the ability to set her method and rate of pay, and in fact, he did set her method and rate of pay. He met all these things. Mr. Ivancic was, again, president, sole shareholder, her direct supervisor. He signed the paychecks. He operated the company day to day. He was the president. There's no question under the FLSA and likewise under Ohio law that he is an employer for purposes of this case. And so the finding of him being personally liable is absolutely correct. Now, appellants have also argued that the court overstepped, I guess, in awarding double damages in this case. but the language of Section 34A is very clear. On its face, it says that damages shall be awarded and damages shall be calculated as an additional 2 times the amount of the back wages. The court correctly calculated the back wages in this case as $3,381.18. It's a simple matter of arithmetic to double those damages according to the Constitution of this state, according to the revised code, and award Ms. Welch the damages that were awarded. Attorney's fees, also not discretionary in this case. Section 34A says attorney's fees shall be paid. We had a hearing on attorney's fees with the trial court. Appellants did not object to counsel's hourly rate. Appellants did not object to any of the hourly billings submitted to the court. In that case, they simply argue in their brief that the attorney's fees and the damages are too large in relation to the amount at issue in this case. The Supreme Court of Ohio has rejected that argument. In Bittner versus Tri-County Toyota, the Supreme Court said that the lodestar method is the proper method for calculating fees. The Supreme Court said essentially that if you reduce fees on the basis of the relationship to the amount, the underlying amount at issue, you gut the statute. And that's what would happen in this case. No attorney would represent Ms. Welch or any other employee seeking a few $1,000s in wages if they could not recover a reasonable attorney fee. So this is an access to justice issue, and Ms. Welch has a right to the full amount of damages awarded in this case, and she has a right to the full amount of attorney's fees in this case. If appellants wanted to avoid attorney's fees, they could have tried to settle the case at any point. One last issue. You know what? I think I've already addressed everything that I had wanted to. Do you have any questions?
Seeing none, thank you.
Thank you.
Counsel, you have just over 2.5 minutes remaining.
No, I'm fine.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.